I don't care where you live. I don't care what you do. You were still under bond condition of this court. I have so many questions.
And Your
What
Honor,
can you just, does mere presence impute criminality?
I observed the defendant open the register, take cash, and place the cash into pocket.
Welcome to Bench Report Court Cam.
Just let her know and then we'll go. Okay. Hi.
Judge, I have 3 appointments, 2 out on bond, 1 in custody.
Okay. Who do you want to talk about?
Bond, I just wanted to see if I could revisit, not really revisit, just kind of modify the bond conditions slightly.
Absolutely. Who are you talking about?
The first one is Mr. Perez, Judge. Jose Perez.
This is a DWI.
Yes, sir.
Okay.
I understand that he lives in Dallas, Judge, and he was wondering if he could do the UA somewhere over there.
So what'll happen is, Perez, come up. Oh, Blasi, you're still here. Wonderful. Yay. I don't care where you live. I don't care what you do. You were still under bond condition of this court. If you do not have a Texas driver license and if you do not have liability insurance, you are not allowed to drive. Do you understand?
I haven't driven.
I am also ordering you not to consume alcohol or illegal drugs. If you get called upon to take a test, you must go to a Quest Diagnostics in Dallas, take a test there, and get the result to your lawyer. It is on you to do that. Typically, when we have someone that does it here, they come into here to downtown and they take a test and I pay for it. But because you're over there, I cannot pay for it. You will be required to foot the bill on that. If you fail to go test when you're called upon, I will issue a warrant for your arrest. There are no more PR bonds. You pick up a new case, you violate any of these conditions. Do you understand? One more thing. I don't know what your immigration status is, but if you go to jail and you're not in this country with permission and you spend any more than 46 hours in custody, you will probably get an immigration detainer and it's not going to go well. So if you're not in this country with permission, you better live like you have a halo over your head. You understand? All right. Good luck. Thanks.
And the next one, Your Honor, is sir.
Just take a seat.
He's also just asking that if he could change the location of his UAs. And I wonder if I could just speak to
Where does he live?
that. In Pasadena, Judge, it seems like
No.
somewhere in South Houston. He said,
Still under bond condition of this court, still required. If some time passes and then he's good, then we can perhaps modify. But this is the beginning of the case. I want to make sure that he's not using it.
Yes.
I don't know him. I've never met him. And so, right, I'm just doing everything that I would do to every single other person. Yeah.
Excellent. Thank you, Judge.
Absolutely.
The last one, Your Honor, is Mr. Francisco Cerda. He's in custody, Judge, and I wonder if there's something wrong with our
Is that C or an S?
It's the Judge.
Okay.
Oh, he's right here.
Good morning, Mr. Cerda. You are charged with engaging in organized criminal activity. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Yes, Judge. On January 21st, 2025, the officer was dispatched to a residence in Harris County, Texas. In the call notes from dispatch state, the reportee says an unknown party stole her neighbor's U-Haul trailer. Subjects were seen headed towards Pasadena Boulevard. The driver was a skinny, tall male, and the reportee lives on Buchanan Street and has camera footage of it happening. A witness stated he observed individuals taking the neighbor's U-Haul. The officers located the U-Haul and a felony stop was conducted. Defendant Hentoja was observed unloading items from the U-Haul, ran to the back of the residence, and prevented officers from arresting him. Defendants Lopez and Cerda remained in the U-Haul, and the complainant stated the value of the trailer was $1,800 and dirt on the trailer was $300.
I have so many questions.
Yes, Judge.
I don't even know where to start.
Judge, that's my concern. If you may, I want to raise some, I guess, some points of argument to the court's attention. The first one, my concern is that, the 911 caller mentioned unknown parties, and then the police officer later mentions a messed up text. without any type of articulable facts, believe that they are the specific people or the individuals that have taken this fuel. Now, as we know, probable cause requires more than a hunch, more than suspicion. It requires something else, more than that. And that seems that that's all that the DIMS, at least under the four corners of the DIMS, allege that my client was involved with this alleged act.
I mean, remember, like, so when they start an investigation, sometimes they just don't have everything, and facts develop in time.
Right.
Here, we have a call that several people have stolen a U-Haul,
Yes, Judge.
and they've given a description of a tall, lanky person,
Yeah.
right?
Yes, Judge. And respectfully, we defer to the court because all it says in the DIMS is that the defendant Serta remained in the U-Haul. There's no further information regarding Serta.
Where was he in the U-Haul? Was he in the actual U-Haul? Was he in the truck that was driving the U-Haul? How was he engaged in this alleged criminality? Like,
And Your
what
Honor,
can you just, does mere presence impute criminality?
Judge, and that's exactly right. Texas law says that mere presence is not enough to
Dude,
bring
I'm with you.
Oh, yes, sir.
But, so,
we're not arguing against that, Your Honor. And like I said, we defer to the court because we don't have that information. We'd have to await the OR, and we don't have that at this time.
but I'm not going to sit here and
Yes,
hold
Judge.
someone.
And that's why we defer to the court.
Let's look at what the statute says, because, you know. $7102.
No. Magistrate. There's no information that gives for this defendant at all. And we have no OR. So just discuss the refile.
You looking at?
Yes. That's great.
A person commits an offense if, with intent to establish, maintain, or participate in any combination or in the profits of a combination, or as a member of a criminal street gang, the person commits or conspires to commit one or more of the following. One is murder, capital murder, arson, yada, yada, yada. Two, any gambling offense punishable by a Class A misdemeanor. Promotion of prostitution. Number four, unlawful manufacture, transportation, firearms. Which one are you relying on?
Your Honor, as it's pled, is that it's pled as theft as being the underlying basis of the engaging in criminal activity. And right now, Kelsey is looking at the case. We may very well dismiss this because of the insufficient evidence in the information in the DIMS. But right now, Chief is looking at it.
And Your Honor, if we could just maybe reset it for a week or so and call the witness.
He's in custody, you know, and I can't. I mean, if he was on bond, that would be one thing, but he's in custody. I'm not going to hold him just because, you know. And the compounding it, Casey, is that he's got an ice hold, so I can't give him a PR bond, you know.
I just need a little more time, Your Honor, to dismiss it right now.
Yeah, I'll find no PC because I just don't think it's there for now. And then if you find something later on, you know, by all means, but all right, Mr. Sird, I'm going to find that there's no probable cause to go forward in your case. Just, Mr. Serta, be careful who you hang out with, you know? Okay. All right, for sure. Ms. Prejean, you are charged with aggregate theft. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. The officer met with the complainant, the Walmart Asset Protection employee, and the complainant stated that he reviewed store surveillance. And on September 12th, 2023, the complainant observed the defendant open the register multiple times, take cash, and place the cash into pocket, a total of $790.41. On September 13th, 2023, the officer observed the defendant conduct a fraudulent return for a total of $60.02. And on September 18th, 2023, the complainant observed another fraudulent return by the defendant for a total of $101.77. On September 20th, 2023, the complainant observed the defendant process a fraudulent return, take money from the register, and conduct a fraudulent return to obtain a gift card following the transaction for a total of $120.64. The complainant stated the defendant did not have permission to take money and desired prosecution. The officer made contact with the defendant, who admitted to stealing from the business 4 times, with each time being $200.
All right, ma'am, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to go to any Walmart for any reason. Do you understand? If I find that you go to Walmart, then I'm going to revoke your bond. I'm going to put you in jail. Did you need a lawyer, ma'am? Okay, I'll appoint you one today. I'm going to have you sign a receipt, Victoria, then we'll have you take a seat in the jury box while we find your lawyer, ma'am.
Thanks for watching. Stick around longer and click the highlighted videos to your right. See you there.